If you are waiting on any immigration case right now, stop everything you are doing and watch this video from the very first word to the very last, because what just happened on March the 3rd, 2026 is going to change the trajectory of your case, your family's future, and possibly your entire life in America. I am not exaggerating. I am not trying to scare you. I am telling you exactly what is happening right now inside the immigration system. And if you do not understand these changes in the next 15 minutes, you could make a mistake that cost you everything you have been working toward for years. Let me tell you something. I have been covering immigration updates on this channel for a long time now. And there are days when I sit down to record and I think, okay, this is a normal update. Some policy tweaks, some processing time changes, nothing earth-shattering. Today is not one of those days. Today I sat down. I read through every single memo, every single policy change, every single internal directive that came out. And I actually had to read some of them twice because I could not believe what I was seeing. This is one of the biggest shifts we have seen in years, and it is affecting almost every single category of immigrant in the United States right now. So whether you are on an H-1B visa, whether you are an international student on an F-1, whether you are waiting for your green card interview, whether you filed for asylum, whether you are undocumented and trying to find a path forward, whether you have a pending work permit application, whether your spouse is waiting abroad for a visa appointment, I need you to stay right here, because this affects you directly. And I am going to walk you through everything step by step in plain, simple English, so that no matter where you are from, no matter what language you speak at home, you will understand exactly what is going on and exactly what you need to do starting today. Let me start with what actually changed, because the news is reporting bits and pieces, and most of it is confusing, and some of it is flat out wrong. Here is what actually happened. USCIS released a major operational directive that changes how they are processing cases across multiple categories. This is not a proposed rule. This is not something that might happen in 6 months. This is already in effect. It went into effect this week. And the changes touch everything from how long adjudications take to how officers are reviewing evidence to what triggers a request for additional evidence or even a notice of intent to deny. The first major change, and this is the one that is going to hit the most people the fastest, is a complete restructuring of how employment authorization documents are being processed. If you have a pending EAD application right now, listen to me very carefully. The processing priority has shifted. USCIS has announced that they are reallocating adjudication resources, which in plain English means that some case types that were being processed relatively quickly are now going to slow down, and other case types that were stuck in backlog are going to speed up. Now, before you panic or before you celebrate, let me explain which categories are affected, because this is where the details matter more than anything. If you filed for an EAD based on a pending adjustment of status, so you are waiting for your green card, and you filed your work permit at the same time, your processing time may actually improve. USCIS has signaled that they are pushing more resources toward clearing the adjustment of status backlog, and that includes the associated EAD and advanced parole applications. This is actually good news for a lot of people who have been waiting 8 months, 10 months, some of you 12 months or more just to get your work permit while your green card case sits in the queue. If this is you, there is a real chance you could see movement on your case in the coming weeks. But, and this is a big but, this only applies if your case is complete. If there are no deficiencies in your filing, and if you responded to any requests for evidence on time, if you missed anything, if there is a gap in your filing, this speed up could actually work against you, because officers who are moving faster through cases are also more likely to deny incomplete applications rather than give you extra time to fix them. Now, here is where it gets more complicated. If you filed for an EAD based on a pending asylum case, the picture is very different. The new directive includes language that specifically addresses asylum-based EADs. And what it says is that these applications will now undergo what they are calling enhanced vetting. That term, enhanced vetting, sounds bureaucratic, but what it really means is that your work permit application tied to your asylum case is going to get more scrutiny. It is going to take longer, and the standard for approval may effectively be higher. Even though technically the legal standard has not changed on paper, what has changed is how officers are being instructed to review these cases. They are being told to cross-reference more databases, to look more carefully at the underlying asylum claim before approving the work permit, and to flag cases where the asylum claim itself appears to have issues. So, if you are an asylum seeker and you were counting on getting your EAD quickly so you could work legally and support your family, you need to understand that the timeline just got longer and the risk of delay or denial just went up. Let me give you a real scenario so you can see what this looks like in practice. Imagine you came to the United States, you filed for asylum, and about 5 months later, you filed for your work permit, because the law allows you to do that after your asylum case has been pending for a certain period. Under the old system, your EAD application would go into the queue. It would get processed in roughly the order it was received, and assuming everything was in order, you would get your work permit. Under this new directive, that same application now gets flagged for additional review. An officer looks at your asylum case, sees that your interview has not happened yet, sees that there are questions about your claim, and instead of just approving the EAD, they put it on hold or they issue a request for more evidence. Now, you are waiting even longer. You cannot work legally. Your savings are running out. Your family is depending on you. And you do not know when or if that work permit is going to come through. This is the reality that thousands of people are about to face, and I need you to understand it now so you can prepare for it. But listen carefully, because this is the part nobody is talking about. There is a provision buried in this directive that could actually help some asylum seekers if they know about it and if they act fast. The directive includes a clause that says if your asylum interview has already been scheduled, your EAD application should be processed under the standard timeline, not the enhanced vetting timeline. What this means is that if you can get your asylum interview scheduled sooner, your work permit application moves faster. Now, I know what you are thinking. You cannot control when USCIS schedules your interview, and that is mostly true. But what you can do is make sure your case is interview ready. Make sure all your documents are submitted. Make sure your address is updated. Make sure there are no outstanding requests from the asylum office that you have not responded to, because when they are looking for cases to schedule, they are going to pick the ones that are complete and ready to go. If your case is sitting there with missing documents or an outdated address, you are going to the bottom of the list, and your EAD is going to sit in enhanced vetting limbo for months. Now, let me shift to something that is going to affect a massive number of people, and that is the change to how green card interviews are being handled. Starting this month, USCIS field officers have been given new instructions on interview scheduling, and these instructions are going to cause a lot of confusion if you do not understand them. The short version is this: they are prioritizing certain categories of green card interviews over others. Family-based cases where the petitioner is a U.S. citizen and the beneficiary is an immediate relative. So, spouses, parents, and unmarried children under 21, these cases are being pushed to the front of the interview line. If you are in this category, you might actually see your interview get scheduled faster than you expected. Some people who filed their adjustment of status 6 or 7 months ago might get interview notices in the coming weeks, which would be remarkably fast compared to what we have seen in recent years. But here is the other side. If you are in a family preference category, meaning you are the sibling of a U.S. citizen or the married adult child of a U.S. citizen, or you are in any of the employment-based preference categories and you are waiting for an interview, your wait just got longer. The resources that were being used to schedule and conduct those interviews are being redirected. I know that is painful to hear. I know some of you have been waiting for years, some of you for over a decade in the family preference categories, and now you are being told to wait even longer. But I want you to understand something. This is about resource allocation, not about your case being denied. Your case is still in the system. Your priority date still matters. Your place in line has not changed. What has changed is how fast that line is moving. And right now, it is moving slower for your category. What you need to do is keep your case current. Make sure USCIS has your latest address. Make sure you respond to any notices immediately. And whatever you do, do not let your medical examination expire. If your medical expires while you are waiting for your interview, you are going to have to redo it, and that is going to cost you more money and more time. Check the expiration date on your I-693 medical form. If it is going to expire in the next few months, talk to an immigration attorney about whether you should get a new one done now. Now, I need to talk to the H-1B workers because what just happened affects you in a way that could change your entire career trajectory. The directive includes new guidance on how USCIS is handling H-1B extensions and transfers. If you are currently on an H-1B and your employer filed for an extension, or if you are transferring to a new employer and they filed a new H-1B petition for you, the adjudication standards just tightened. Officers are being instructed to more carefully scrutinize whether the position genuinely qualifies as a specialty occupation, whether the salary meets the prevailing wage requirements, and whether the employer-employee relationship is legitimate. This is not new in theory. USCIS has always had these standards, but what is new is the level of enforcement. Officers are being told to issue more requests for evidence and more denials when they see red flags, even on cases that would have been routinely approved a year ago. Let me paint you a picture. You are working for a consulting company. Your H-1B is up for renewal. Your employer files the extension. Under the old approach, the officer would look at it, see that you have been on H-1B for 3 years already, see that the job and the salary look reasonable and approve it. Under the new approach, that same officer is now asking for more documentation about your specific job duties, about where you physically work, about whether you are actually performing specialty occupation work, or whether you are doing something that does not require the degree that your H-1B is based on. They want client letters. If you work at client sites, they want detailed project descriptions. They want organizational charts. And if your employer does not provide all of this quickly and thoroughly, you are looking at a denial. A denial on your H-1B extension means you could lose your status. You could have to stop working. You could have to leave the country. This is not theoretical. This is happening right now to real people. So, if you are on an H-1B, here is what I need you to do immediately. Go to your employer, go to your HR department, and make sure they are aware of these changes. Make sure your immigration attorney is aware. Make sure that your H-1B petition includes comprehensive documentation. Do not rely on what was enough last year. It is not enough this year. You need client letters. You need detailed job descriptions. You need evidence that your role requires the specific degree you have. And you need to make sure your salary is at or above the prevailing wage for your area. If any of these things are weak, you need to fix them before your case is adjudicated, not after you get a request for evidence, because at that point, you are already on the defensive and the odds of approval drop significantly. And stop right here for a second because I need to say something important. If you are finding this information valuable, if this is helping you understand what is going on, I need you to do something for me right now. Hit the like button. I know it seems small, but it makes a massive difference. When you like this video, YouTube shows it to more people who need this information, and these are people just like you, people whose lives depend on understanding these changes. So, hit like right now, and if you have not subscribed to this channel yet, do it now and turn on the notification bell because I am covering these updates every single day, and the situation is changing fast. You cannot afford to miss what comes next. Also, drop a comment right now telling me your visa type and your priority date. I read every single comment and I want to know who is watching so I can make sure I am covering the updates that matter most to you. Now, let me get to something that is going to be very emotional for a lot of you, and I want to handle this with the seriousness it deserves. The changes that just took effect include new guidance on how USCIS and immigration enforcement agencies are coordinating. Without getting political, I will tell you exactly what this means in practical terms. If you are undocumented, if you have an expired visa, if you are out of status for any reason, your risk level just went up. The new directive includes provisions for increased data sharing between USCIS and enforcement agencies. What this means is that information that you provide to USCIS in your applications could potentially be accessed by enforcement. Now, I want to be very clear about something. This does not mean that everyone who has ever filed an application is going to be targeted. That is not how it works. But what it does mean is that if you file an application and it gets denied, or if you have a case that reveals you are out of status, that information is now more likely to be shared with ICE than it was before. This puts a lot of people in an impossible situation. You want to come forward. You want to fix your status. You want to do things the right way, but now you are afraid that the very act of trying to fix your status could put you at risk. I understand that fear. It is valid, and I'm not going to tell you what to do because every situation is different. What I will tell you is this: do not file any application. Do not take any action without talking to a qualified immigration attorney first. Not a notario, not a friend who went through the process, not someone on social media. A licensed immigration attorney who can look at your specific situation and give you specific advice. The stakes are too high right now to guess. One wrong move could mean the difference between staying with your family in America and being separated from them. Now, here is something that I think represents a genuine opportunity, and I do not want you to miss it, because so much of what I have been saying is heavy and scary. There is a provision in the new directive that expands premium processing to additional case types. If you are not familiar with premium processing, it is a service where you pay an extra fee to USCIS and they guarantee that your case will be adjudicated within 15 business days. Previously, premium processing was only available for certain employment-based petitions. Under the new directive, premium processing is being expanded to include additional categories. And this is significant because it means that if your case type is now eligible, you can pay the fee and get a decision fast. I am talking about weeks instead of months. For some people, this could be life-changing. If you have been waiting for a decision and the wait has been destroying you financially or emotionally or professionally, and your case type now qualifies for premium processing, this might be the move you need to make. Check the USCIS website. Check with your attorney and find out if your case is eligible. Do it today. Do not wait. Let me also talk about what this means for international students, because I know a huge portion of this audience is on F1 visas or on OPT or trying to transition from student status to a work visa. The new guidance has implications for how STEM OPT extensions are being reviewed. Officers are being told to more carefully verify that the training plan, the I-983 form that your employer fills out, actually matches what you are doing day to day. If there is a mismatch between what the form says and what you are actually doing at work, that is now a red flag that could lead to a denial of your OPT extension or even a finding that you violated your status. So if you are on STEM OPT right now, pull out your I-983 form, read it carefully, and make sure it accurately describes what you are actually doing. If your role has changed since the form was filed, you need to update it. Talk to your employer. Talk to your designated school official. Get it fixed now before it becomes a problem. And for those of you who are planning to travel outside the United States while you have a pending case, please listen to me. The rules around advanced parole and re-entry have not changed on paper, but the way they are being applied at ports of entry has shifted. There are increasing reports of people with valid advanced parole documents being subjected to secondary inspection when they re-enter the country. Secondary inspection means they pull you aside. They ask you additional questions. They may review your entire immigration history, and in some cases, they can make a determination right there at the airport that affects your pending case. I am not saying do not travel. I am saying be prepared. Carry every document with you. Carry your advanced parole document, your receipt notices, your employment authorization card, proof of your pending case, evidence of your ties to the United States. Have everything organized and ready to present. And if you have any complicating factors in your case, if there are any issues, if there is anything that could raise a question, seriously consider whether this trip is worth the risk right now. Sometimes the safest thing to do is stay put until your case is resolved. But now stop for a moment, because here is something critical that almost no one is going to tell you. These changes that I have been describing, they are not the end. They are the beginning. What we are seeing right now is the first phase of a larger set of changes that are expected to roll out over the next several months. I have been hearing from sources who work within the immigration system that additional directives are being prepared, and some of them are going to be even more impactful than what we have seen so far. I cannot share all the details yet because some of this is still being finalized, but I can tell you that if you think today's changes are significant, what is coming next could redefine how the entire immigration system operates for years to come. That is why you need to be subscribed to this channel. That is why you need to have notifications turned on, because when those changes drop, I am going to be here breaking them down for you the same way I am doing right now, and you need to hear it first, not after it is too late. Let me now give you a clear action plan, because I do not want you to walk away from this video feeling overwhelmed and not knowing what to do. I want you to walk away knowing exactly what steps to take. First, log into your USCIS account and check your case status right now. If you do not have an online account, create one. Link your cases to it. Check for any updates, any notices, any requests for evidence that you might have missed. Second, review every document in your immigration file. Make sure everything is current. Make sure your address is updated with USCIS. Make sure your passport is not expired. Make sure your medical examination is still valid. Make sure you have copies of everything. Third, if you have a pending case of any kind, contact your immigration attorney this week, not next month, this week, and ask them whether these new changes affect your case and whether there is anything you need to do differently. If you do not have an attorney, find one. Many attorneys offer free or low-cost consultations. This is not the time to handle your immigration case alone. Fourth, do not make any major moves without legal advice. Do not travel. Do not change jobs. Do not withdraw an application. Do not file a new application. Do not do anything until you understand how these changes interact with your specific situation. Fifth, stay informed. The immigration landscape is shifting rapidly, and what is true today might change tomorrow. Subscribe to this channel, turn on notifications, and check back every single day, because I am going to be covering every development as it happens. I know this video has been a lot. I know some of what I said today is scary. I know some of you are sitting there right now with your heart beating fast, wondering what is going to happen to your case, to your job, to your family. I want you to know that I see you. I understand what you are going through. The immigration process is one of the hardest things a human being can go through. The waiting, the uncertainty, the fear, the hope, the sleepless nights, the constant checking of your case status. I know all of it. And I want you to know that this channel exists for you. Every video I make is for you. Every update I cover is because I know there is someone out there who needs to hear it. Someone whose entire future depends on understanding what is happening in the immigration system right now. So, if this video helped you, if it gave you clarity, if it gave you even a small sense of direction in the middle of all this chaos, share it with someone who needs it. Send it to your family member who is waiting for their case. Send it to your coworker who is on an H-1B. Send it to your friend who is afraid to ask questions because they do not know who to trust. This information needs to reach every single person it can help. Now, before I go, I need to tell you this. There is one more change that just came through as I was preparing this video, and it is so significant that it deserves its own full breakdown. I am recording that video right now, and it is going to be on this channel within the next 24 hours. If you thought what I told you today was big, what I am about to reveal next could be the single most important immigration update of this entire year. Do not miss it. Subscribe, turn on that bell, and I will see you in the very next video. Your future in America may depend on